Before we get started, I just want to say that I saw a really exciting video this week, and Mr. Tweedy was on it. It was really, it was well done. I really appreciate it. It was a good message you had as well. Of course, the governor's message was well done as well. And but also there was a call for me in here from somebody about you from CNN. So I don't know. I'll get back to you on that. No, seriously, though, good job. Well, it appears that it's 1 o'clock or 1100, whatever that time says up there. So we'll start the meeting in any case. First of all, we have the reading of the meeting minutes of September 3rd, 2025. Are there any additions, corrections to those minutes? Hearing none, is there a motion, please?
I move we adopt the minutes. September 3rd, 2025.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any abstentions, any noes? The motion carries unanimously. We have public comment. I'd like to recognize Representative Burns from the Newark area, who has sponsored a bill that's, I think, a very positive one for his and all the constituents of the state of Delaware. And welcome, Representative Burns, and we look forward to hearing from you right now.
Thank you very much, Commissioner, and thank you everyone for giving me this opportunity to speak. I'm here to speak in favor of proposed order 10829, the large load tariff. I want to commend the commission and everyone involved with being proactive on this measure. I speak with a lot of legislators from many states that are retroactively trying to figure out how to deal with large loads that have been put on their systems. And I want to commend you for the work that you've done on this and to encourage you to move forward with that proposed order. Thank you.
Thank you very much, Representative. Is there anyone else who wishes to make any public comment? There appears to be no one else. The consent agenda. Anyone have any desire to take anything off the consent agenda? Commissioner Conaway.
That we adopt the consent agenda as presented.
I second it.
Is there any discussion on the motion to approve the consent agenda? Hearing no comments on that. All those in favor, let's make a motion to, we made the motion yet?
Yes.
Okay.
Second.
Fine. All those in favor of the motion signify by saying aye.
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 Any abstentions, any negatives? There are none. Motion carries. Representative Burns, we're on that path that you've set us on. Thank you so much. You're welcome, obviously, to stay here through our exciting meeting, or to obviously depart when you desire. Okay, we got to go to the regular agenda. Number one is in the matter of the application of Chesapeake Utilities Corporation for a general increase in its natural gas rates and for approval of certain other changes to its natural gas tariff. We have Mr. O'Brien on behalf of Chesapeake. Welcome, Mr. O'Brien.
Thank you, Chair and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. The caption on the agenda is a little confusing, but the docket number is correct. This is docket number 25-0834, which is Chesapeake's annual GSR filing. So what you have before you in this docket is proposed order number 10825, and it's the opening order in our GSR adjustment case. So as you know, the GSR is a dollar-for-dollar pass-through of the company's cost of gas, which includes a true-up from the prior period to ensure that only actual costs are recovered from customers. This order is a typical opening order for the GSR in that it designates a hearing examiner for the purpose of considering petitions for intervention, sets an intervention period, directs the company to publish notice of the rate changes, and permits the proposed rates to go into effect on November 1st, which are then subject to staff and DPA's review of the application. The company thanks staff for putting the order together and asks that you approve proposed order number 10825, which again is the opening order for our annual GSR case. Thank you.
Thank you, Mr. O'Brien. Ms. Workman?
Thank you, Chair. Kate Workman for staff. First, I want to point out that the increase requested as a result of this rate case is that statutory increase that we always have at the beginning. It's 306A. And so the commission really does not have discretion to refuse that statutory increase. As a result, staff requests that the commission enter order number 10825. Thank you.
Thank you very much. Mr. Crumpler?
The public advocate, Jameson Tweedy, has a few comments.
Kate and Bill laid it out correctly. This is a pass-through of costs, so there's little discretion for the commission. But I did just want to highlight that these are substantially increasing costs that will hit ratepayers. The request was to have them go into effect in November, so they will, if that's ordered, that will go into effect for the winter heating season. So we need to be aware as all of these costs continue to compound for ratepayers. These ones are the pass-through costs that Chesapeake incurs to procure and deliver the natural gas that everyone uses, but it will hit ratepayers nonetheless. Thank you.
I appreciate that. We're well aware of the impact upon the rates to customers, and obviously our eyes are all on any matter that might be causing increases at this time. Commissioners, do you have any questions of the parties?
Move that we adopt proposed order number 10825 as presented.
I'm sorry, I have a comment before we second that.
Second it and
I will second that, and I do have a comment. That increase is not lost on us. I ran the numbers using my own, bills, the past bill, the bill, the big bill last January, and this is a significant understanding that it's a pass-through, but this is what's happening with gas prices, capacity and supply and demand, and this is something we're seeing, and it's going to be very unfortunate for a lot of people because it especially residents, it is significant, this increase. $1.12, something like that per CCF. I mean, this is big. These are big numbers, and we're not paying attention as well. Thank you. And I second.
20 years ago, fluctuation of the big gas prices was fairly routine, and also the oil prices. Then Delaware got pretty smart. We started doing the auction. We started bifurcating it into three parts so that we had 2 up years and 1 down year. It sort of helped keep things under control. Problem now is that we've gotten into the lower gas prices with the fractions, all the fracking that's going on. Now we've come to a period of time when the supply is not up to the demand, and we've had obviously 3 auction years now where the prices have all gone up. There's nothing to help us on the situation. Pray that next year that the prices back down again. So anybody has any ideas or thoughts on what we can do, I'm very receptive to your input. And I would ask if there's any further discussion. Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Any noes, any abstentions, the motion carries. Thank you, Mr. O'Brien, Ms. Workman, and Mr. Crumpler.
Thank you.
Number 2 is in the matter of the regulations governing tariffs, which set forth rates, terms, and conditions with the attachment to any pole, duct, conduit, right-of-way, or other similar facilities of any public utility. This is Public Service Commission Regulation 1004, excuse me. Kate Workman, please.
Thank you, Chair. Kate Workman on behalf of staff. Today, we're coming to request an order from the commission regarding regulation 26 Delaware Admin Code 1004. I'm not going to read the whole name of it. We're going to call it the pole attachment regulation. The regulation outlines the rights and responsibilities of public utilities as it relates to any pole attachment agreements. Pursuant to the regulation, utilities must file all pole attachment agreements with the commission within 30 days of the mutual execution of said agreement. Recently, the commission staff has fielded some complaints and questions from parties to pole attachment agreements and from those parties who would like to seek to enter such agreements, which brought to staff's attention that the last pole attachment agreement that we reviewed was in 2006. So staff believes there are newer, more current ones out there, and staff is respectfully requesting that the commission enter order number 10826, which would order the public utilities to file all their current pole attachment agreements within 30 days of the order, provide notice to each attaching entity which is a party to those agreements, and file proof of sending that notice to the commission within 45 days of the date of the order, and then to file all future pole attachment agreements in accordance with Regulation 1004. So we're really just asking for an order to give the companies notice that we want to see their pole attachment agreements and that in the future we're going to be looking for those. Thank you.
Thank you. Commissioners, do you have any questions? Commissioner Gray?
Mr. Chair, I'll move that we adopt order number 10826 as submitted.
I second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any noes? Any abstentions? The motion carries. Thank you, Ms. Workman. And thanks to staff. It might seem sort of small, but those attachments are very important to a lot of utilities. And so I'm glad that this is on the calendar and it's going to go forward. Okay. Number 3 is in the matter of the adoption of regulations for community energy facilities to implement the provisions of the code as amended. And we have PSC regulation docket number 3013 before us with proposed order 10828. And Mr. Ferguson is handling this matter.
Yes. Thank you, Mr. Chair. Stephen Ferguson on behalf of staff. Staff requests an order from the commission to make updates to regulation 3013 related to rules for and regulation of community energy facilities. On June 4th, 2025, the commission issued order number 10723, which reopened the regulations. Staff has proposed amendments to regulation 3013 to increase efficiencies, make improvements to customer solicitation process, and other revisions to comply with the Delaware Registrar of Regulations style manual. Staff held a public workshop on August 7th to review the amendments with interested stakeholders and receive feedback. After that workshop, staff made additional revisions based on that feedback received and posted them to the docket on August 11th. Staff then requested any additional comments or feedback be provided by September 5th. No additional comments or feedback were received. I would also note, should the commission approve the publication of the proposed amendments to the regulation, the process will proceed in the ordinary course under the APA with a public comment period and a public hearing on the proposed changes. For those reasons, staff recommends the commission adopt order number 10828. Thank you.
Thank you, Mr. Ferguson. Commissioners, do you have any questions? Commissioner Gray?
Thank you, Mr. Chairman. Mr. Ferguson, were the public advocate and DENREC part of the working group, or have they weighed in on the changes that are being proposed?
I believe they did have an opportunity to weigh in. Yes.
No further questions, Mr. Chair.
Any further questions? Commissioner Correa?
I move that we adopt the order number 10828.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Anybody opposed? Any abstentions? The motion carries. Thank you, Mr. Ferguson. Number 4 is in the matter of the petition of TPE Development LLC for waiver of the co-location restriction in the code. And we have proposed order number 10843 before us. And we have Mr. Wallace, I believe. Welcome, Mr. Wallace. Please explain your application.
Yeah, good afternoon, and thank you, Chairman Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of TPE Development LLC. We filed a request that the commission grant a co-location waiver for what will be 3 community energy facility projects in the aggregate, each up to 4 megawatts, in the aggregate up to 12 megawatts. The crux of the request is that we waive Rule 2.1.3, which prohibits that co-location, as the commission is aware from prior discussions on similar waivers. The statute doesn't include a prohibition or on co-location. This was a creature of the regulations. The draft regulations that were just addressed in the prior matter on the agenda include removal of the operative co-location rule. And so what we're asking for here is a waiver while that regulatory process is pending, so that these projects can move forward with the interconnection process with Delmarva, begin the study process, and in discussions with Delmarva, we need to get that waiver in place in order for them to begin the study. So we are, excited to move forward. This is a relatively remote area of the DPL service territory, so there's not a lot of other great sites nearby, and there's available capacity on the substation. So it's a really good candidate for having a project configuration like this. And then, of course, it's going to advance Delaware's clean energy goals by making, instead of 4 megawatts, up to nearly 12 megawatts available to Delaware residents to subscribe to and receive the benefits from. So I'm happy to answer any questions that you have. We have more details in our filing, but and ultimately we're asking that the commission adopt and issue proposed order 10843 granting the waiver.
Okay, thank you very much. Mr. Crumpler?
BPA is in support of this.
Staff?
Kate Workman for staff. Staff has reviewed the application and does not oppose the entry of order number 10843.
Commissioner Gray?
Mr. Chair, I'd like to move that we adopt order number 10843 as submitted.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? Any abstentions? Motion carries.
Good luck, Mr. Wallace.
Best wishes. Get it done. Tell Mr. Green I said hi.
He says hello.
Thank you. Number 5 is in the matter of staff's petition to compel Delmarva to update the interconnection standards for Delmarva Power and Light Company's Delaware operating territory. It is docket number 251048. And I believe we have Ms. Workman.
Yes, Ms. Workman for staff once again. On September 18th, 2024, after receiving numerous complaints from solar or community solar developers about Delmarva Power's interconnection process, the commission opened docket number 24-1012 to identify barriers and solutions to the interconnection process. Unfortunately, there have yet to be any final standards presented to staff to review. To my knowledge, to date, only one community energy facility has been successfully interconnected since the community solar interconnection queue opened in November of 2021. Further, as a result of the One Big Beautiful Bill signed into law on July 4th, 2025, tax credits for solar projects is going to end in December, the end of the year 2027. So staff's position is that we're on a bit of a time crunch now to get these projects interconnected. Because the community solar developers in Delmarva have been working on interconnection standards for over a year, but have not yet completed the process, in conjunction with the time constraints set by this One Big Beautiful bill regarding tax credits for solar projects, staff requests that the commission open a new docket and order Delmarva and the community solar developers to file a full red line standards document within 45 days of the date of the order, which would be by December 1st, 2025. A hearing examiner should be appointed to process requests to intervene and to develop a procedural schedule. Staff respectfully requests that the commission enter order number 10845, which would approve the petition and open that docket to update the interconnection standards. Thank you.
Thank you, Ms. Workman. Obviously, I don't see Delmarva at the table, but they're in the room, and we've heard, along many months about issues relating to interconnecting community solar or solar. And it really is getting to crunch time, and we're looking forward to having good news about the number that are connected, and that the problems that we presently have are ironed out, so that we don't this discussion again. And naturally, if you like to say a few words, you're welcome to, Michelle.
Thank you, Commissioner, Chair Winslow and Commissioners Zishang Shen on behalf of Delmarva Power and Light Company. I do appreciate the opportunity just to make a few comments regarding this docket. As Ms. Workman stated, and as the Commission is aware, there's already an active open docket number 24-1012, which addresses the interconnection standards. And I note that along with Delmarva, the Coalition for Community Solar Access, or CCSA, DENREC, and numerous solar developers are already parties to that docket. And within that current proceeding, Delmarva and CCSA have been working collaboratively for the past year or so on reviewing and revising the interconnection standards. I think you have before you Hearing Examiner Kenton's letter, and the attachment to that letter reflects the significant progress that we've made on the interconnection standards. We've reached consensus on as many provisions as possible, and there's there are currently a few remaining sections that are in the process of being finalized. And so Delmarva had been preparing to file the updated standards in the current docket 24-1012 in conjunction with CCSA. And we do understand now that there's being proposed an entirely separate docket. That's, I think the idea is to work in parallel with 24-1012. And Delmarva is, prepared to abide by the timelines and requirements, and had already been anticipating being able to submit the revised standards in short order.
Thank you very much. Commissioners, do you have any questions? Mr. Gray?
Thank you, Mr. Chairman. Ms. Workman, if I look at item 3 on the agenda, docket 3013, where you're implementing provisions for community energy facilities and you're getting comments, I don't know what your deadline close date on that is. Is that related? Would that be a foundation upon which Delmarva and others need to put their standards in place?
No, those are separate issues. The interconnection standards aren't, we're not planning to make them regulatory at this time. The 3013 is the regulatory process. What we're talking about now is just the standards that the community energy facilities and Delmarva would have with each other.
Okay. So I think what I heard from Delmarva is that the 45-day proposed duration deadline is doable and acceptable. Is that what I heard?
Yes, Your Honor.
Okay. I have no further questions, Mr. Chair. Thank you. Thank you, Ms. Workman.
Mr. Drexler?
I move that we adopt proposed order number 10845 as presented.
Second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposed, any abstentions? Motion carries. Thank you very much, everyone. Number 6 is in the matter of Chesapeake Utilities Corporation, Delaware Division, 2025 Infrastructure Safety and Reliability Plan, the final report. And we have with us again, Mr. O'Brien.
Thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. This docket relates to Chesapeake's proposed Infrastructure Safety and Reliability Plan, or ISR plan, for planning years 2025 through 2029, which Chesapeake filed in April as a proposed plan, and then after answering discovery and meeting with staff and DPA, filed its final plan early last month. Staff and DPA, along with their consultant, reviewed the plan and found that it complied with the Commission's ISR regulations. What you have before you is proposed order number 10849, which includes a Commission acknowledgement that the plan is consistent with the ISR regulations. The order also includes the usual caveats stating that the acknowledgement does not constitute pre-approval of any capital spending and that the parties may challenge such spending in a future rate case. The company thanks staff and DPA for their work on this case and for putting together the order and asks that you approve proposed order number 10849. Thank you.
Thank you, Mr. O'Brien. Mr. Ferguson?
Thank you, Mr. Chair. Stephen Ferguson on behalf of staff. Staff recommends the Commission enter proposed order number 10849, acknowledging the Chesapeake's final gas ISR plan that was filed on September 4th, 2025, is consistent with the requirements of ESC Regulation 8.03. Staff agrees with Chesapeake's representations today concerning the ISR plan's relevant filings, the parties' comment, and the ISR plan filing process, and supports Chesapeake's request and the proposed form of order. Accordingly, staff recommends the Commission adopt order number 10849. Thank you.
Thank you, Mr. Ferguson. Mr. Crumpler?
Nothing further to add from DPA. We also echo what staff in Chesapeake has said.
Thank you. Commissioners, any questions? Commissioner Conaway?
Move that we adopt proposed order 10848 as presented.
I second the motion.
Point of order, Mr. Chair.
49, isn't it?
It's one.
108. It's okay. 10849.
Motion's amended to 10849. Was there a second? I didn't hear the second. You seconded? Okay. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any noes, any abstentions, the motion carries.
Thank you.
Mr. O'Brien, as you notice, there's a lot of interest in what's going on in the gas area, especially prices. Another, it's amazing what might happen. One of the votes I regret making years ago was about a gas line that was supposed to go from wherever it ended into Sussex County deeper. And I forget exactly why the commission voted against it, but that never happened, and we never got that gas line. We thought that come back with an alternative plan, but you surprised us and you didn't. Anyway, that's one of the reasons I've called you about something that's not on our docket and not in our future docket, but just as a matter of discussion, I'd like very much to talk to you about that whole situation because, we don't have much electricity generation in Delaware, and Sussex County is a possible spot. So I would appreciate some discussion with you on that issue.
Very good. Very good. We look forward to that.
Thank you. Okay, number 7 is in the matter of Delmarva Power and Light Company 2024 Infrastructure Safety and Reliability Plan. And we have proposed order number 10848. And we have, well, you're not Ms. Shen, obviously. Mr. Jordan, welcome.
Thank you, Chair Winslow. Commissioners, may it please the Commission, Brian Jordan for Delmarva Power and Light Company. And this will be similar to what Mr. O'Brien just recited. with the difference being that this is Delmarva Power and Light Company's infrastructure, safety, and reliability plan for the years 2025 to 2029, and the commission has before it proposed order number 10848. We're asking that the commission adopt that order, and to support that, I would note that Delmarva filed its natural gas ISR within the regulations deadline on April 28th, 2025. That was followed by discovery between the parties, which produced some recommendations from the joint staff and DPA consultant. Delmarva filed its final ISR, gas ISR, on August 26, 2025. And then what followed were comments submitted on behalf of staff and the public advocate, followed by Delmarva's. And what I would point out, as the commission is aware of its role with these ISR dockets, is today is to review and acknowledge that the ISR that was filed complies with the regulations. All the parties agree that it does. The one thing I would point out that the commission would see in Delmarva's comments is in paragraph 6. And the reason I bring this out specifically is because there was a recommendation to set some annual outage rates and average outage duration metrics. And there was a proposal recommendation to establish those values for the annual outage rate at 0.00403 and for the annual average outage duration as 453. Delmarva does not oppose that recommendation, but would just point out that that's not necessarily within today's, with what's in front of the commission today. Today is just to review and acknowledge that the ISR meets those requirements. And with that, I also want to extend my and the company's gratitude to staff and the public advocate for the participation in this process and for drafting the order. Thank you.
Thank you. Mr. Ferguson.
Yes, thank you. Stephen Ferguson on behalf of staff. Staff's position is the same as Chesapeake's gas ISR plan. Staff recommends the commission enter the proposed order number 10848 that acknowledges that Delmarva's final gas ISR plan, filed on August 26, 2025, is consistent with the requirements of Regulation 8003. Staff agrees with Delmarva's representations today concerning the ISR plan's relevant filings, the parties' comment, and the plan filing process, and supports Delmarva's request in the proposed form of order. Accordingly, staff would recommend that the commission adopt order number 10848.
Thank you, Mr. Ferguson. Mr. Crumpler.
I agree with staff and Delmarva. Similar to the Chesapeake matter, we ask that the commission enter the order.
Thank you, Mr. Crumpler. Mr. Gray.
Mr. Chair, I have a question and I'll make a motion. Mr. Jordan, I looked at the ISR and I just have a question, and this may extend the scope of the chair's request to Mr. O'Brien. I noted that in some of the data, there's a new LNG liquefier, and I'd like to know more about that, but in a separate forum, maybe offline from this conversation. I just wanted to make that note before I make the motion to adopt your ISR using order number 10848 as submitted.
Thank you, Commissioner Gray. And your wish is granted because I believe that's a topic in the pending gas-based rate case. So it will be coming before the commission in one form or another.
I second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Are there any opposed? Any abstentions? The motion carries. Thank you, gentlemen.
Thank you, Chair Winslow. And that concludes my matters in front of the commission today, if I may be excused.
Absolutely.
Thank you.
Thank you for your participation. Number 8 is in the matter of the application of Delmarva Power and Light Company for approval of modifications to its gas cost rates. We have Ms. Shin.
Good afternoon again, Chair Winslow and Commissioners. Zishang Shen on behalf of Delmarva Power and Light Company. On August 28th, 2025, Delmarva filed its annual application requesting approval to modify its gas cost rates, or GCR. The GCR reflects the cost of natural gas Delmarva purchases for its customers with no markup or profit to the company. As the commissioners have acknowledged earlier in the agenda, these costs are driven by what we've been seeing in the market as far as gas prices. The application includes proposed modifications to charges as laid out in the application. And Delmarva respectfully requests the commission enter proposed order number 10850, opening the docket for the 2025 through 2026 GCR period. This order allows the proposed GCR changes to go into effect November 1st, 2025, with proration and subject to refund following the commission's final decision. The proposed order sets a deadline of November 7th, 2025 for petitions for intervention and objections or written comments by November 28th, 2025. And Delmarva thanks staff for preparing the proposed order and for allowing us the opportunity to review and comment. Thank you.
Thank you very much. Ms. Workman.
Thank you, Chair. Kate Workman on behalf of staff. Once again, I will remind the commission that the increase requested that would go into effect November 1st is that same statutory increase that we discussed earlier. And so the commission does not have the discretion to refuse that increase. Staff requests that the commission enter order number 10850 as presented. Thank you.
Thank you. Mr. Crumpler again, right?
Yep. And the public advocate, Mr. Tweedy, would like to provide some comments to the commission.
Please.
So just the same basic comments as before with the Chesapeake GSR, same for the Delmarva GCR. These are pass-through costs, and as Ms. Workman said, there's very little ability to scrutinize them because they're pass-through costs. But this is a significant increase. One of the components is going up 43%, and that will hit ratepayers at the same time as the winter heating season is starting, and at the same time as Delmarva has a pending gas base rates case. So these are all impacts on customers that will pile on top of each other and affect Delawareans. So this, of course, is just the opening order, and these are pass-through costs. But thank you.
Thank you, Mr. Tweedy. Sounds like November would be a good time to take a vacation. Commissioners, any questions of the parties? Mr. Conaway?
I would move that we adopt proposed order number 10850 as presented.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? Any abstentions? Motion carries. Thank you all very much. We have a hearing today in the matter of the application of Chesapeake Utilities Corporation for a general increase in its natural gas rates and for approval of certain other changes to its natural gas tariff. And we have proposed order number 10851 before us, and we have, I understand, a settlement between the parties. And I believe that Mr. O'Brien is the lead on this one. Welcome again, Mr. O'Brien.
Thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. I also have with me Matthew Everingham, Assistant Vice President of Regulatory for the company. We also have two other members of our regulatory team here, Jeffrey Weiss and Michael Reno. As you're aware, this is the evidentiary hearing regarding Phase 2 of Chesapeake's application for a rate increase and other tariff changes filed August 12th, 2024. You approved the Phase 1 proposed settlement on June 18th of this year by order number 10753. In Phase 1, the Commission approved, among other things, the overall revenue requirement, and you deferred to this phase the rate design, the weather normalization adjustment, miscellaneous service charges, and other tariff changes. So you have before you today a Phase 2 proposed settlement, which, if adopted, will resolve all remaining issues in this case. So in other words, there would not be a Phase 3. We do have a preliminary matter for the Commission. The settling parties jointly request that the Commission revoke its designation of a hearing examiner for this Phase 2, which it made by order number 10534, so that the Commission can consider the proposed Phase 2 settlement directly today. We make this request because the revenue requirement has already been approved, There are no more contested issues on these Phase 2 rate design components. And by granting the motion, we'll shave a couple of months off this Phase 2 schedule. So depending on your preference, the commission could vote now on that joint motion or could wait till the end of today's proceeding.
We'll vote now on that matter. Seems that's something that we should get done right away.
Move that we revoke the approval of order number 10534.
Second the motion.
Excuse me. Would I guess would I just add to that, which I think it was Glenn Kenton, right?
Correct. It would just be one part of that order would be revoked, and that's the designation of the hearing examiner for Phase 2.
I asked it to, go ahead.
Make a motion to revoke the approval of Glenn Kenton as the hearing examiner in this case. The settlement agreement for Chesapeake Utility Company's tariff changes. Is that correct, or do you want different?
I believe that's very good. No problem. You're out of here. We want Glenn to be out of the case, and I think that's what your motion says.
So I second the motion.
Does anybody have any questions or concerns about the motion? If not, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Please proceed, Mr. O'Brien.
Thank you. You also have proposed order number 10851 before you today, which, if accepted, will approve the Phase 2 proposed settlement and will also grant in writing the preliminary request to revoke the commission's designation of the hearing examiner. As another preliminary matter, the commission should have the expanded exhibit log for today's hearing listing 27 exhibits. The first 25 were admitted during the Phase 1 evidentiary hearing, and the last 2 are new for today. Those are Exhibit 26, which is the Phase 2 proposed settlement, and Exhibit 27, which is the proof of publication of notice for today's evidentiary hearing. It is my understanding that the parties agree that the last 2 exhibits on the exhibit log are admissible, and therefore I would like to offer those exhibits into evidence.
Without objection, exhibits 26 and 27 are admitted.
Thank you. The company, if it please the commission, would call its first and only witness, Matthew Evergam, and ask that he be sworn. Thank you. So, Mr. Evergam, please state your name, business address, and position with Chesapeake Utilities Corporation.
My name is Matthew Evergam. My business address is 500 Energy Lane, Dover, Delaware, 19904. I'm the Assistant Vice President of Regulatory Affairs with Chesapeake Utilities.
And have you testified before this commission before?
Yes, I have. I've testified in Chesapeake Utilities' most recent base rate case before the Delaware Commission in 2015, as well as in Phase 1 of this rate case. I've also testified in various gas sales rate proceedings before the Commission.
And what was your assignment in this docket?
My assignment in this docket was to lead Chesapeake's regulatory team in preparing the application and responding to discovery. I also participated in the settlement discussions and reviewed the Phase 2 proposed settlement reached by the parties.
Would you please summarize the terms of the Phase 2 proposed settlement, which has been admitted as Exhibit number 26?
Yes. The revenue apportionment, rate design, and rates depicted in Exhibit A to the settlement will, if approved by the Commission, be final for this Phase 2. Such rates reflect modified rate design, including consolidated these 2 standard residential rate classes into one, modifying the declining rate block structure for residential and general service 1 classes, standardizing the expansion area and the underserved area customer charges for residential and general service 1 classes, modifying the underserved area surcharge rate structure for the underserved area, and terminating the interruptible rate schedule and designated all customers currently taking service under interruptible rate schedule as negotiated contract customers pursuant to individually executed service agreements. In addition, the company agreed to maintain the existing rate classes, including expansion area rate classes, but with new names for the non-residential rate classes. The rates as well as the tariff changes are depicted in the clean and red line tariff attached hereto as Exhibit B. Additionally, the miscellaneous service charges as filed shall be approved as final rates for Phase 2. The existing and new miscellaneous service charges are reflected in the red line tariff at sheet numbers 6.375 to 6.376, attached hereto as Exhibit B. Additionally, we have effectively grandfathered the DSIC rate for negotiated rate customers because their contract have fixed negotiated base rates, which do not include the recovery of DSIC plant that is rolled into base rates for other customers as part of this rate case. Without doing that, without that adjustment, the customers on tariff rates would have absorbed this loss revenue from DSIC from the negotiated customers. So this was appropriate to keep the base rate paying customers whole. The parties also agreed to certain changes to the company's transportation program and its facilities extension policy, and the company will convert its billed units from CCF to therms. And finally, the company withdrew its request for a weather normalization adjustment.
Since filing the Phase 2 proposed settlement in the docket for this proceeding, did the company discover any errors in the tariffs that are attached as Exhibit B to the settlement?
Yes, there is one minor correction that should be made. The parties agreed to a service connection charge of $90. Under Section O of the filed tariff, the service connection charge is properly identified under the column for the rate. However, in the description of the charge under the rate, the company inadvertently left in the old charge.
So how does the company propose to fix that?
After discussing the error with staff and DPA, we decided that if the commission adopted the Phase 2 settlement, proposed settlement today, we'd follow up with a letter to the docket correcting that one tariff sheet.
All right, let's shift gears a little. Do you believe that the terms of the settlement agreement are just and reasonable and in the public interest?
Yes, I do.
Can you please explain?
The settlement represented a compromise on the issues from the settling parties. The resulting rate design represents a fair and equitable recovery of the revenue requirement from all customer classes, and the miscellaneous service fees are appropriate for the scope of work performed. Also, by settling the case when we did, we saved a substantial amount of rate case expense. We reached a settlement before the due date for staff and DPA's rebuttal testimony, which hopefully saved a good amount of time, effort, and money on their behalf as well. We also avoided cost to prepare for litigation, which again involves our outside consultants, as well as the staff and DPA outside consultants and outside legal costs. Not to mention the time and effort that would be required from members of staff and DPA when both agencies are facing multiple major cases. This case involved many months of discovery, meetings, calls, and comprehensive negotiations between the parties. The diverse interests of all parties were addressed in the settlement, and while no one got everything they wanted, we believe the end result establishes just and reasonable rates for our customers at this time.
Thank you, Mr. Evergam. I have no further questions at this time. Mr. Evergam is available for cross-examination or for any questions from the commissioners.
Mr. O'Brien, would you have him, for the record, state what the impact is on the consumers?
The impact from this rate case settlement, this is just the rate design, so any impact, there is no additional rate impact to the customers from this Phase 2 of the settlement.
Just want to make sure it's clear. Okay,
Mr. Chairman, I do have a question, please.
please proceed.
Thank you. So I did hear you say in this rate design that you're converting your units from CCF to therms. Okay, so will there be any conversion factors carried on the ratepayers' bills?
The exact representation on the customer's bills, I would have to double check with our billing department and I could get back to you, but I do not know off the top of my head exactly how that will show.
Okay, that's for me a little problematic because how will a mechanical meter present units for customers to account for their consumption?
There is a formal process where we utilize the BTU units to convert from CCF to therms that is in the tariff, is explained in the tariff. But as far as on the bill, I do not know, but there's the methodology I know is included in the tariff.
Yeah, well, I'm worried about the ratepayer because if I'm consuming gas and concerned about my bill, I'm going to go to the mechanical meter and the meter is going to say CCFs. So how am I going to get the therms to be able to reconcile my bill?
Yeah, again, the only thing I can say is that I know that it's laid out in the tariff how it's reconciled. I know that is our normal billing. We bill in therms in every other state that we have. But I would maybe have to talk a little bit more to our customer care team about the information and the sharing of the knowledge on that, Commissioner Gray.
Okay, I just don't want to be inundated at the commission from ratepayers who can't figure out whether or not they can account for the consumption that they've had because you've converted to therm. So maybe the answer is to show some conversion factor on the bill that allows the consumer to reconcile that with their meter.
I will take that back to our billing department. And to be clear, I'm not positive we don't. I just don't know off the top of my head if we actually do, but we will double check that. And that is a good suggestion.
Thank you very much.
Commissioner Gray, Ms. Marshall would like to add a comment.
During the first phase of the discovery, we did ask a question about the bill. They actually do have the conversion factor on the bill. We received a sample bill with the conversion factor on there from CPS to therm. That was proposed to go through, I believe, for more than a year going forward afterwards, but they do have the bills that have the conversion on there, and it's right on the first page.
Okay.
It is a huge section of that first page.
It's a relief to hear that. Thank you for that feedback. And I would suggest, just as a suggestion, do you consider leaving it on the bill? Because in a year from now, it's going to be the same challenge.
Absolutely, we'll take that back.
Hey, Ms. Workman?
Thank you, Chair. Kate Workman on behalf of staff. Staff would like to call their first and only witness, Ms. Shauna Marshall, and ask that she be sworn in.
Yes.
Please state your name and business address for the record.
Shauna Marshall, my business address is 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware 19904.
By whom are you employed?
Delaware Public Service Commission.
What is your position with the commission?
Utility analyst.
And are you the case manager in this docket?
Yes.
Did you participate in the Phase 2 proceedings for docket number 24-0906?
Yes, the parties engaged in multiple discussions, discovery, and negotiations since the Phase 1 settlement was approved in order number 10682.
Can you identify the contested issues for Phase 2?
Yes, Phase 2 was reserved for the company's proposed net weather normalization adjustment, the combination of combining the company's two residential classes into one, the phasing out of the decline in block rates, revising the underserved area rates, and termination of the expansion rate classes. It also included the revenue apportionment, the company's proposed miscellaneous service fees, and the proposed tariff modification.
Was the settlement reached in regard to the contested issue in Phase 2?
Yes, and the settlement agreement is marked as Exhibit 26.
Can you briefly describe how the parties settled the rate design and revenue apportionment issue?
The parties agreed on a CCF to therm conversion factor that will be updated monthly. The rate structure discontinues the interruptible tariff rate schedule and moves customers to individually negotiated contracts. The block rates for residential and general services 1 class will be limited to 2 distinctions, the first 50 CCF and over 50 CCF. The customer schedules and other block rate structures remain unchanged with the exception of new homes for non-residential classes. The monthly customer charge for residential service 1 and 2 is $17, up from the current charge of $13.50. Revenue apportionment for the residential service class code will account for 14.96% of the increase in total base revenue.
In regard to the remaining issues, what is the agreement amongst the parties?
The parties agreed that Chesapeake will withdraw its weather normalization rider. We also agreed with Chesapeake's proposed miscellaneous service fees. Chesapeake agreed to modify its line extension policy to an allowance of 100 feet of main service pipe for new single-family residences. Furthermore, the discontinuance of service section of the tariff was modified to comply with HB 62, and margin sharing will remain the same at the 80-20 split.
Can you briefly summarize HB 62 and the changes to tariff sheet number 6.325?
Yes, currently the company's tariff reflects the following requirements from HB 62. The company cannot terminate service for non-payment without a 14-day written notice during the heating season, identified as period of November 1st through March 31st. The company cannot terminate service for non-payment when the temperature is below 35 degrees Fahrenheit. The tariff does not include the customers who are experiencing hardship during the heating season or who currently receive assistance through LIHEAP, SSI, POC, or TANF programs should contact Chesapeake to review their payment options. But it should be updated to reference to this within 15 days after approval of the settlement agreement.
Do you believe the proposed settlement agreement results in just and reasonable rates and is in the public interest?
Yes, I do.
Can you explain the reasons for your belief?
Settlement represents over 4 months of negotiations to settle the remaining contested issues on docket number 24096. Staff believes that the agreement balances the needs of ratepayers and Chesapeake's ability to provide adequate service. The Phase 2 settlement agreement is just and reasonable, and therefore staff respectfully recommends that the Commission approve the Phase 2 settlement as presented.
Does this conclude your testimony?
Yes, it does.
Thank you, Ms. Marshall. Ms. Marshall is now available for any cross-examination.
No cross from the company. Thank you.
Mr. Crumpler,
No cross-examination from DPA.
anything further, Mr. Escada?
No, staff has nothing further. Thank you.
Mr. Crumpler?
DPA calls its first and only witness remotely, Mr. Glenn Watkins, if he can be sworn in.
Dr. Watson, are you present on the phone? Or on
I was
mute?
instructed to be on mute until now, so hopefully.
Mr. Watkins, can you hear me? Mr. Watkins, can you hear me? Are you on mute?
Mr. Tweedy's contacting right now.
Mr. Watkins just called me to say he is on, but he's speaking, but for some reason it's not coming through here.
Mr. Watkins, can you hear
Yes,
us?
can you hear me now?
Yes.
Sure.
All right.
All right.
Sorry about
No worries. Mr. Watkins, can you state your name and business address for the record?
certainly,
you
but
sw-
I haven't been
Hold
sworn
on.
in yet.
Let's make sure you're sworn in. Thank you.
Sir, if you could just raise your right hand. Do you swear
Very
or
good.
affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Again, Mr. Watkins, can you state your full name and your business address for the record?
Yes, my name is Glenn A. Watkins. My address is 6377 Matawan Trail. That's Mattawan, Mechanicsville, Virginia, 23116.
And sir, who are you employed by?
Technical Associates Incorporated.
And what's your position with Technical Associates?
I'm president and senior economist.
And briefly, Mr. Watkins, what's your educational background?
I hold an MBA and a BS in economics from Virginia Commonwealth University.
And could you describe for the commission your experience in working on matters related to public utility regulation?
Certainly. As set forth in my pre-filed direct testimony previously provided, I've been involved in public utility regulations since 1980 and have provided expert testimony on more than 300 occasions.
And specifically, what about with the Delaware Public Service Commission?
I've been here once or twice. By last count, this is my 29th appearance before the commission.
Very, very good. And what was your role in this phase 2 aspect of this proceeding that we're here for today?
I was engaged by DPA to evaluate the company's proposed class revenue apportionment, or revenue distribution, as we sometimes call it, residential rate designs, and certain proposed tariff changes.
And did DPA reach a settlement with Chesapeake on phase 2 issues in this case?
Yes, we did.
Okay. And Mr. Watkins, did you participate in those negotiations?
Yes, extensively.
And Mr. Watkins, if you could briefly describe the history and structure of Chesapeake's residential rates for the commission.
Sure. First, and for many years, DPA and I have been concerned and have objected to Chesapeake's declining block volumetric rate structure. Second, Chesapeake's residential rates are somewhat atypical in that currently there are essentially 5 separate residential rate schedules with different rate designs. These include a bifurcation between small and large residential customers, as well as different rates for what are referred to as the legacy area, the expansion area, and the underserved area.
Mr. Watkins, in terms of the settlement agreement here, are there significant changes to the various rates and rate structures across the 5 separate residential rate schedules?
Yes, indeed there are. The settlement agreement calls for a multitude of changes relating to residential rates. In this regard, both the company and DPA, as well as staff, were challenged with numerous constraints and objectives in designing the agreed upon residential rates. Specifically, I'm happy to report that the settlement agreement reflects a significant yet gradual movement towards the elimination of the current declining block rate structure. Furthermore, the settlement agreement provides for uniformed volumetric rates across all residential rates. The settlement agreement also continues to protect legacy customers from the higher cost to serve newer customers within the expansion and underserved areas by continuing to have higher fixed charges along with an underserved area volumetric charge that is new to this case, but is revenue neutral to what we've been doing in the past. As might be imagined, there were numerous moving parts that had to be considered and evaluated within the ultimate agreed upon residential rates and rate structures. Within these so-called moving parts, compromises were made particularly with respect to fixed monthly customer charges, as well as the design of what is referred as the tail block or third usage volumetric block rate for higher consumption. While the DPA and Chesapeake, as well as staff, had different priorities and objectives regarding the design of residential rates, I can unequivocally say that the compromises made by all parties are the result of probably the most collaborative effort I can remember in terms of redesigning residential rates, which result in fair and reasonable rates to all customers, and at the same time limit increases to specific customers, and are a significant movement towards the objective of promoting conservation and the efficient utilization of natural gas within Chesapeake service area.
Mr. Watkins, following up on that, your answer there, does the settlement agreement also reflect compromise in terms of the various tariff changes?
Yes, it does. With regard to tariff changes, DPA's primary concern related to the mains and services extension policy within the tariff. In short, it is fair to say that DPA got what it really needed and wanted in terms of protecting customers against uneconomic expansions within Chesapeake's service area. DPA also agrees with the proposed changes to miscellaneous service charges, such as after-hour reconnections, fees, service calls, new connections, etc. Indeed, they are cost-based.
Mr. Watkins, in your opinion, is this settlement in the public interest? And if so, why is it in the public's interest?
Yes, it is. In large part, the settlement agreement accomplishes many goals that DPA has long advocated for and is certainly in the public interest in terms of residential ratepayers' interest. Yet the proposed rate design will provide every opportunity for the company to recover its cost of providing safe and reliable service.
Mr. Watkins, is it your understanding that the commission staff also supports the settlement under consideration here today?
That is my understanding, yes.
Okay. Mr. Watkins, if you can answer any cross-examination that the parties might have or questions from the hearing examiners.
Ms. Workman?
No cross-examination from staff. Thank you.
No cross-examination from the company. Thank you.
Commissioners, any questions?
That's all from DPA.
Commissioners?
I move that we adopt the order number 10851.
Second the motion?
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, any abstentions? The motion carries. Ms. Marshall, thank you very much for your efforts and everybody else as well. And best wishes. Next, we have our Executive Director with his comments.
You, Chairman Winslow and Commissioners, I did want to update the Commission very briefly on some regional electric issues that have been happening. Commissioner Drexler and I last month attended the PJM Governor's Technical Conference in Philadelphia, and last week the OPSI annual meeting in Washington, where both meetings were dominated by large loads and how to deal with them. As Representative Burns mentioned earlier, this is a national issue, but within PJM, states are at various stages in terms of trying to adopt large load tariffs and kind of get their arms around this issue. And it doesn't appear as though anyone has an answer or a model that that we could emulate here, but we'll try to do our best with the Delmarva tariff and try to thread the needle between supporting economic development while also protecting customers in classes that are not in that large load tariff. At the OPSI meeting, also at the technical meeting, another issue was PJM governance. We discussed having 205 filing rights for OPSI, and that would allow OPSI to file comments at FERC or complaints at FERC regarding the PJM tariff. Other RTOs, states and other RTOs have these rights. So it's something that the governors are very interested in and something that OPSI is pursuing. Happy to answer any questions, or Commissioner Drexler may add more color.
And I think, what's important to note is we spend a lot of time with the market monitor when we're at these meetings. And, he prepares those big books that we get, and the summary books. And I mean, he contends that we're seeing a lot of rate increases related to supply and demand and the increasing supply. And that increasing supply across the PJM footprint is coming from data centers, the 81 data centers in Virginia, the data centers in Ohio. It affects us. That, in his opinion, affects us more than any other reasons. And that's why we're seeing higher rates even in Delaware. So it's very important to us, whether or not we ever have a data center, whether or not the proposed data center comes to be here. Any data center is going to affect us, and that's really, really important. Looking at the most important thing, and one of the market monitor's other points is, we really need to see more generation, replacing generation that's been taken off the grid, including the Indian River coal plant. Everybody has great ideas about how to replace generation, but with supply chain problems and timing issues and how to do it and what to do, it really is very complex, and it's ever changing. But we are hearing almost exclusively about these data centers, and we're working hard at OPSI among the board right now to either get those 205 rights or something similar and how we would use those. So we're really involved with PJM weekly now, both with some of the new board members there, some of the things we seek with what's going on with planning and Rule 1920. And we have a separate group called Parsec that's dealing with Rule 1920 about planning and how we as states get involved with planning, how much say we have with planning. And again, the new generation is overshadowing everything. And interestingly, we're looking at, and what is also proposed is co-location of generation. When you are opening a data center, as you know, data centers today require a tremendous amount of power, and co-locating a generating unit nearby or in conjunction with or owned by, if data center developers even want to own generation, that, would solve a lot of the problem. And that comes with its own complex set of rules. But right now, discussions revolve around, co-locating new generation, how we solve the problem issue of data centers. And so those are the things we're looking at OPSI, and it's quite interesting. And I know Mr. Tweedy was also at both of those, the tech conference up in Philadelphia, as well as the OPSI meeting. And I don't know if you had any thoughts about those meetings as well, but thank you.
Yeah, thank you both. I think you've hit many of the really important points. And I would just echo that some of the themes that were at both of those conferences were the extraordinarily large and rapid growth in demand from data centers and the relative slow timelines that new generation can be built because of supply chain constraints, because of just the logistics and permitting of building. And so those two timelines don't match up very well right now. And that could be a tremendous problem. The predictions from PJM as to what they expect new load growth to be versus what PJM has told us about the amount of new generation that has been coming online in recent years just simply don't match up. And so we need to be extraordinarily attentive to those issues. So thank you both.
One important cost is not only the purchase power or the oil or the natural gas, but what I've been reading also is a price of copper wire, which are sustainable for the electric transmission. Also the substations, part of it, and also the transformers. Now, a lot of these things are made in China, and they are imported and paid for and what have you. So that is also going to affect the prices to the consumer when they pay the bill. So I request OPSI and all other groups to keep in mind that other costs are equally important as purchase power, power generation, and what have you.
All good points, good comments. And I give kudos to my colleague here, Kim Drexler, for being engaged with OPSI. It's like herding cats. You've got 13 jurisdictions with 13 governors and different policies, and PJM is trying to reconcile all of them. And along comes data centers, and it undermines practically everyone in every state. We're certainly impacted because we're in the PJM footprint. Even if they build data centers in Virginia, it can impact us here in Delaware. I have one question in terms of the PJM meeting. They were searching for new leadership. Is there any word or indication that they have found a new leadership yet?
So we, as the board of OPSI, have been meeting with the president of the board of PJM on a monthly basis on a call. I will say that they were very close to a new CEO to replace Manu. I guess a couple of weeks ago, when we met in DC last week, they indicated that the two that they were down to were not going to be viable candidates. So the search for a new CEO starts over.
They probably ran when they saw the challenge.
We did have the opportunity to meet the 3 new board members of PJM. They are all from Massachusetts, various backgrounds. One of the new board members with whom we were particularly impressed was Matt Nelson, who was a commissioner up in Massachusetts, and he was very involved in the meeting that we had with that board, with the board-to-board meeting. So I think he's a good asset to the board there. 2 others also involved in Massachusetts in energy one is a Harvard professor, and I can't remember what the other person does. But anyway, they're a good asset. I think they're a good addition. There was a lot of it was a big issue that 2 of the members, 2 of the board members did not get reappointed or revoted by the membership. It was a big deal, but I believe that the 3 people that they've taken on will really add to that board, and particularly the former Commissioner Matt Nelson. So that was also part of that meeting last week.
So, Matt, I have 2 or 3 bullet points I'd like to just bring to the table. So I anticipate that the commission is going to have new legislation governing our decision-making next year, from the business to the prudence rule. And so I'm still interested to know if we get some legal orientation before we get to that milestone and make that transition. And furthermore, I would be very interested as a commissioner to get some presentation from the Delaware Energy Office, because I know that the policies in DC are disrupting a lot of the renewables investments and plans and offshore wind. And from their perspective, shared with us, it might be very valuable. Thank you. No further comments, Mr. Chair.
Thanks. I'll contact the Energy Office and have them request that they appear at one of our future meetings. And Chair Winslow, our next meeting is November 5th.
Okay, thank you all very much. We are now adjourned. Thank you, Representative Burns.